Hey everybody. So just a quick review of what we've been doing for the last couple of days. We've been talking about the judicial system. On Monday we talked about the federal judicial system and the court system, and the levels of courts in the federal government. Remember, it's Supreme, Appellate, and District. In the North Carolina court system is a little different. There is supreme and appellate, just like in the federal government, but there is also a superior and district court because in North Carolina, most cases start on the state level, and so they divide the lower level into two to kind of speed things up and keep everything going. Today, we're going to talk about the different types of cases that will go through court system, and we'll just go ahead and jump straight into that. First type is a criminal case, and a criminal is anyone who has violated the law. And in a criminal case, obviously someone's broken the law and a crime has been committed. It says give 3 examples of criminal cases. Criminal cases, a lot of times people think about things like murder, kidnapping, rape, arson, and all those are criminal cases, but criminal cases are also things like speeding or tax evasion or anything that breaks the law. And honestly, most crimes are not violent related crimes. In a criminal case, the two sides are the prosecutor, that will be the state, or the district attorney on the federal level, who is trying to put the defendant in jail, and the defendant is whoever is accused of committing the crime. Then you have civil cases. In a civil case, no crime has been committed, but there are two parties involved. There could possibly be more than two parties involved, but it's typically just two parties. And examples of civil cases would be like divorce or child support, or maybe damage to property where you sue someone else. And in those scenarios, there is a plaintiff versus a defendant. And I know you've probably watched judge shows on TV like Judge Judy or Judge Joe Brown, and those are actual real life examples of civil cases, although those judges are not actually judges. They are arbitrators, and we'll talk more about that later. So, what happens when you go to court? Well, all cases start at the district level, or I say all cases, most cases start at the district level. Remember, on the federal level, if it's a foreign diplomat case or a state versus state, it will start directly in the Supreme Court. After the district level, you go to trial, and the jury rules guilty or not guilty in your trial. If found, the judge will issue a sentence after the jury reaches a verdict, and the judge finds his sentence or her sentence from the state's penal code or the U.S. penal code, which is essentially like a crime and punishment menu. Like in North Carolina, if you commit murder, you have a mandatory life sentence. And we'll talk more about that later. After you have been found guilty, your lawyer can appeal if they feel like the law has not been applied fairly. A lot of people will appeal in the event that they are found guilty, even if they don't have any ground to stand on. People don't like going to jail, so typically they file appeals. The appeals court will decide whether to remand, overturn, or keep the district decision. If they remand, remember that means to send to a lower court, which means something has happened in your case. The law was not applied fairly, but they don't think that you should just be found not guilty because the law wasn't applied fairly, so you are given a new trial in a lower court. If your decision is overturned, that means that your lawyer proved without a doubt that you are not guilty, and so the 3 judges that sit on the appeals court decided to overturn your verdict. Or they will keep the district decision, which means you remain guilty. And so your last line of defense is the Supreme Court. If you have some type of constitutional issue, so anything that has violated your rights that come from the Constitution, like the amendments or something in the articles, you can go to the Supreme Court. But you can't just file an appeal and say, well, I don't want to go to jail. I feel like I didn't do it. You actually have to have evidence from the Constitution that your rights have been violated in order to go to the Supreme Court. So if a case does go to the Supreme Court, what happens? Well, the Supreme Court selects case for docket and reviews lawyer briefs. So I will say this, like literally thousands of cases are filed with the Supreme Court, but they're only able to hear a couple hundred cases a year. And honestly, it's only 9 people on the Supreme Court, so that is a lot for them to do. And every time they hear a case, they have to write up their decision to be published. So it's a lot, and they just really don't have time to hear every single case. Oral arguments take place for which justices ask questions. They're asking questions to your lawyer, to you. They ask each other questions about the Constitution. And remember, the judicial branch's job is to interpret the law, so each justice is interpreting the Constitution in their own manner. Justices have a conference and vote, and the majority wins. So after they hear the case, they just sit down and they talk about it. They come up with different opinions, and they write those opinions down. Whichever opinion has the most votes is the opinion that wins. Remember, what is a quorum? A quorum is just a majority of justices that are there in order to hold court. And so they're, again, like I was saying, their decisions are written and released to the public. The majority decision is the decision that won, that most of the justices called or thought. A dissenting decision is a minority decision, meaning the least amount of justices thought that. And a concurring decision is a decision that agrees with either the majority or the dissenting, but for a different reason. So a couple years ago, for example, gay marriage was ruled to be legal based on the 9th and 14th Amendments. Well, let's say the 9th Amendment guarantees you the right to marry who you want to, and let's say 5 of those justices agreed that based on the 9th Amendment, gay marriage is legal. But let's say that 2 justices decided that they do agree that gay marriage should be legal, but not because the 9th Amendment guarantees you the right to marry who you want, but rather that all citizens should be treated equally. That would be a concurring decision because they agree that gay marriage should be legal in that sense. However, they think that the 14th Amendment is the reason that gay marriage should be legal. So how do they decide? They look at relevant articles or amendments, meaning they go into the Constitution and see if your court case has anything to do with any of the 27 amendments or any of the 7 articles. They look back at precedent, so they look back and see what previous judges have decided and how they decided. Remember, precedent can change. For instance, in Plessy versus Ferguson, it was found that black people and white people must be segregated as long as the facilities were equal. But then later on, in Brown versus Board of Education, it was found that segregation is not actually fair. And so the precedent changed for how African Americans and whites would be treated in relationship to one another. And then there's always stare decisis, which means let the decision stand, which means they don't think that your court case has anything to do with the Constitution. All right, guys, that's all I got for you today. I hope that you are having a good day, and I look forward to seeing you.